Court documents show that yesterday a grand jury indicted Florida State University shooting suspect Phoenix Ikner on 2 counts of first-degree murder and 7 counts of attempted first-degree murder with a firearm. That came just a day after his first appearance in Leon County Court. We know this is a case that is getting a lot of attention, and we will now want to kind of look ahead and see what the next steps are, what we can expect as this case moves forward. And so joining us live now via Zoom to talk about that is Stacey Felter, an attorney with Felter Law. And Stacey, we really appreciate you joining us this morning here on Fox 35 News Plus.
Thank you for having me.
All right, so first appearance, he has been indicted, being held right now without bond. What are some of the next steps that we will be watching for in this case?
Absolutely. It is my understanding he was indigent, so he has received a public defender. I believe the first steps will be to have what's called an Arthur hearing, a bond hearing. That because he's held on zero bond, a lot of people will ask me questions. Why isn't the bond set? In any case, don't we have a right to a bond? When it's a punishable by life, there's several crimes that do not guarantee that you have that the court will give a bond on those charges. So in this case, it was denied bond, and so the public defender will most likely do what's called a motion for bond and have what's called an Arthur hearing to show that he's not a danger, that he's got somewhere to live. There's a lot of factors that go into it, and there will be a hearing on that. The chances are probably unlikely that he will receive a bond in this case, especially due to the high profile, the high profile.
Yeah, I was going to ask kind of what factors the court would be looking at in kind of deciding that. It would be hard to kind of fathom that he would be granted a bond.
Correct. So is he a danger to society, to himself? Where is he going to live? Does he have a job? There's a whole lot of factors that go into it. Due to what happened and what he's accused of happening, and the allegations against him, it's going to be very difficult to be able to prove with the court to allow him out on bond. The defense attorney will argue that it's very difficult to work on the defense, to get him evaluated, to do anything that is necessary to give him a fair shot at his defense if he is still in the county jail.
Now, we know he was being held in Wakulla County, had been transferred there because of the connection kind of with the sheriff's office in Leon County. Would this be something that could prompt a change of venue at some point to another county, or would you think this is a case that would end up staying in Leon County Court, even with him being held in another county?
And that is a great question. I've had several clients where there has been a conflict on which county and county jail that my clients are held in, and they spend their time on zero bond, or if they can't produce bond, then they sit in a different county because of that conflict. Does not necessarily mean that there will be a change of venue. That's just for the conflict situation. The defense attorney will need to go ahead and make the move to have the venue changed if that's what the defense decides to do. But that does not mean that it's leaving Leon County.
A case like this that is so high profile that according to the arrest affidavit, it sounds like there is a lot of video showing many of the things that are kind of laid out in in the affidavit, in the charges against him. It's, I would imagine, a difficult situation for a public defender to kind of find themselves in.
And I was previously a public defender in the Ninth Circuit. So it is a difficult thing, but understanding that there are things that the public defender can do, including some gag orders, making sure, because there is going to be a lot of media attention on this case. It's not just Florida. There are a lot of families around the country, maybe the world, that had students attending Florida State at the time. So it is going to have a lot of media attention, but there are some things that the public defender may be able to do to limit the exposure, to gag certain things that could be exposed to the public.
Do you expect those to be motions that we see coming from Ikner's team likely?
I would assume so. And we hate to say it, but sometimes certain crimes only have a short window. So it depends on how much attention the case gets. If it does become a problem, there's a lot of talking, it's tainting any sort of jury pool, no matter where the jurisdiction is. I would assume that they would make a motion for gag and not to have certain witnesses or other people talking about the case.
All right, Stacey Felter from Felter Law, we really appreciate your perspective, and thanks for joining us this morning here on Fox 35 News Plus.
Absolutely. Thank you for having me.